Welcome to the podcast for the development of American law. Have any of you read William Golding's Lord of the Flies? To refresh your memory, or for those of you whom haven't had a chance to read this interesting book, it tells the story of a group of young boys who find themselves alone on a deserted island. They attempt to develop rules and a system of organization, but without any adults to oversee and establish order, the boys eventually become violent and brutal. The message of the book is that human nature is fundamentally savage, without set rules and order or laws. Although it may not feel this way at times, we do not live in this type of society pictured in The Lord of the Flies. Why not? Well, we have what is known as positive laws. What is positive law? It is defined as a set of rules made and enforced by the government. They are meant to apply to everyone, and in order to be legitimate, the law must be seen as rational, fair, and just. Positive law comes in several forms: the Constitution, statutes, which is a law enacted by the legislature, ordinances or law enacted by local governing body, executive orders or an order issued by an executive such as the president or the governor, a treaty, which is an agreement between countries, a regulation, which is a rule passed by a regulatory agency, and a judicial decision, which is a decision by a court of law. One example of a positive law is during the COVID-19 outbreak, protesters of certain parts of the nation claim the government overstepped its rights by mandating citizens stay at home. These protesters gathered at state capitals to mostly peacefully express their rights, although we know of unpeaceful protests as well. Those that protested said they were protected to do so under the Constitution's First Amendment of freedom of speech and assembly. One example of positive law. Now that we know the definition of positive law, can you think of any problems with this definition? The law does not always apply to everyone. For example, in a simple scenario, driver A gets away with speeding while driver B gets a ticket. Also, the law is not always perceived as rational, fair, and just. Now, before there was ever positive law, humans had to rely on their sense of what was right and wrong to determine how to act. This concept is known as natural law. Natural law flows from man's natural condition. It has to do with people's sense of morality and justice, or what is right and what is wrong. It's a philosophical concept as opposed to enforceable rules. For example, the Declaration of Independence states that all men are created equal and have inalienable rights to life, liberty, and the pursuit of happiness. Are these natural rights that all humans should enjoy? Yes, most of us would agree that all men, and hopefully women too, are equal and have these inalienable rights. Aside from being natural law, what other type of law is the Declaration of Independence? I am sure you are all answering to yourselves, positive law. The Declaration of Independence is part of the Constitution. It is also positive law. Natural law and positive law do not always get along. What happens when they conflict? For example, take a highly controversial law, the death penalty. This is positive law in certain states where the death penalty is permitted. Those who oppose the death penalty may cite to the Bible, "Thou shalt not kill," or their own sense of justice, which is natural law. Such a conflict provides a basis for criticism and sometimes even disobedience of positive law. Rebelling against the positive law is known as civil disobedience. One example of civil disobedience you are all familiar with is the civil rights movement. You all know that segregation and discrimination was at one time authorized by law. The civil rights movement protested against these positive laws. How did MLK and protesters justify the right to break these laws? By beliefs in morals in a higher form of law. Keep in mind, even murder broadly defined, the killing of another human being, is not absolute across time and culture as natural law. Natural law appears to be culturally defined. After all, how else can we explain so many differing views on whether the death penalty is considered murder or whether killing an enemy on battlefield is murder? A simple statement that murder is wrong and against natural law requires more than a little thought. Simplistic definitions of natural law, you know in your heart that it's right, is that different people have different hearts or different natures, if you will, and so do different cultures. The idea of natural law is very complex. The legitimacy of law can break down into both substantive and procedural legitimacy. Substantive legitimacy has to do with the content of the law. A law is substantively legitimate if people believe it is based on fair, just, and reasonable principles. It has to do with the actual substance of the law or the content of the law. Procedural legitimacy has to do with how the law is enacted and applied. A law is seen as procedurally legitimate if the law is enacted, applied, and enforced according to procedures that people regard as fair, just, and reasonable. Now that we understand the definition and application of the law, let's discuss a bit of its history. Those of you who have watched The Tudors or Downton Abbey may have seen some courtroom drama which is not unlike our own back in America. And this would make sense. You see, American law is derived largely from English common law, dating back to 11th century. King's judges settled disputes. These judges looked at decisions of their colleagues for guidance. Common law grew out of this system. The idea that courts look to past similar issues to guide their decisions became known as the doctrine of stare decisis. These past decisions, which help determine future decisions, are known as precedent. Stare decisis is the doctrine that obligates courts to look to precedent when making their decisions. This is an important concept today in both English and American legal systems. For example, this example might sound familiar if you are a fan of The Crown. Let's say Queen Elizabeth II has promised Princess Margaret in 1950 that Princess Margaret can take her place as queen 10 years later in 1960. "1960 arrives, but Queen Elizabeth changes her mind, telling Princess Margaret that the princess parties too much and will not make a reliable queen. Princess Margaret sues Queen Elizabeth for breach of contract, and the judge rules in favor of the princess, arguing that the queen and the princess had formed an enforceable contract, and the queen had breached the contract. The remedy is specific performance, or, in other words, the queen must hand over the throne to the princess. That decision becomes precedent. From now on, lower courts in the same jurisdiction are expected to follow this new rule. When a country's ruler promises to pass title to the throne to another, that ruler is contractually obligated to carry out that promise. Lower courts will follow this new precedent because the doctrine of stare decisis tells them they must. The common law also made a distinction between criminal law and civil law. Criminal law sought to punish people for offenses against the crown, whereas civil law provided remedies for private wrongs. These principles apply today. One example is the infamous O.J. Simpson case. Here, you had both a criminal case, the state versus O.J. The state had lost that case, and there was a civil case, the family of the victims versus O.J. There, the families won their case. The criminal case involved criminal charges, while in the civil case, the families sought financial damages for their loss. No podcast would be complete without a review of some of the concepts you all learned in middle and high school. Remember the concept of separation of powers. The framers of the Constitution did not want to create a parliamentary system with one central power. So they created 3 branches of government in order to distribute the power amongst 3 different branches. These 3 branches included the executive, legislative, and judicial branches. In doing this, the framers created a system of checks and balances. This means, for example, that the president may veto bills passed by the Congress, but Congress can override the presidential veto. What about the judiciary? The Constitution is silent on how the judiciary can check and balance the other branches. However, in a case from 1803 called Marbury versus Madison, the Supreme Court asserted the power to review acts of Congress, known as laws, and declare them null and void if found to be contrary to the Constitution. This is known as judicial review. Today, both state and federal courts exercise this authority. The best way to explain judicial review is by example. One example is Roe versus Wade, a 1973 case in which the U.S. Supreme Court overturned a Texas law prohibiting abortion. This Texas law was found to be unconstitutional. Another example is Brown versus Board of Education, a 1954 case in which the U.S. Supreme Court overturned state laws permitting racially segregated public schools. Again, these state laws were found to be unconstitutional. A more recent example is the U.S. Supreme Court in Obergefell v. Hodges, which struck down laws prohibiting same-sex couples to marry. The court found that those laws violated the 14th Amendment's guarantees of due process and equal protection. Speaking of constitutional amendments, hopefully you are all familiar with some of the rights protected in our Constitution's amendments. How did these amendments come to be? Congress enacted the first 10 amendments to the Constitution, known as the Bill of Rights. There was a concern that the Constitution did not go far enough in protecting individual rights. The idea was to prevent abuses of power by the government. If you have not read them, I highly recommend that you do. Or even if it has been a while, I do recommend that you refresh your memory. And this concludes our podcast.